दोस्तों इस क्लास में आपको डिक्टेशन दूंगा मैं 100 WPM पर 600 वर्ड्स की डिक्टेशन है, आपको डिक्टेशन में प्रोवाइड कर रहा हूं। बी रेडी फॉर इट। The first respondent is a partnership firm based in Amritsar, which is inter alia engaged in the import of cement. It imported a consignment of 1400 bags of cement from Pakistan under an invoice dated 1 February 2019. A truck crossed the zero line with a Pakistan customs cargo manifest. The goods arrived at the Land Customs Station Road Cargo, Amritsar, on the same day. The truck unloaded its cargo at the Central Warehousing Corporation. The first respondent filed bill seeking clearance of the goods for home consumption. The bill of entry was self-assessed under the provisions of Section 17(1) of the Customs Act 1962 under Customs Tariff Heading 252 by levying nil customs duty in terms of notification. The duty payable was assessed. Notification prescribed a preferential rate of duty on specified goods originating in the Islamic Republic of Pakistan. A notification was issued by the Ministry of Finance in the Department of Revenue in exercise of powers conferred by subsection 1 of Section 8A of the Customs Tariff Act 1975. On the other hand, the contention of the Union government before the High Court was that under Section 15 of the Customs Act 1962, the relevant date for determining the rate of duty is the date of the presentation of the bill of entry. The submission was that the amended rate of duty under a notification came into force, hence the importers were liable to pay duty on the basis of the amended rate. The purpose of the notification being to discourage the import of goods from Pakistan, it has prospective effect. The object and purpose is not to penalize Indian importers who had completed their imports, presented bills of entry for home consumption, and had completed self-assessment in terms of the provisions of the Customs Act and the regulations prior to the issuance of the notification. The submissions which were urged have been supported by other learned counsel appearing for the respondents. In the case of other goods, it is the date of the payment of duty which determines the rate of duty under clause C of section 15(1). The proviso to section 15(1) contemplates a situation where a bill of entry has been presented before the date of the entry inwards of the vessel or the arrival of the aircraft or vehicle through which the goods are imported. Under the proviso to section 46(3), a bill of entry may be presented at any time not exceeding 30 days prior to the expected arrival of the aircraft or vehicle by which the goods have been shipped for importation into India. Dealing with such a situation, the proviso to section 15(1) states that if a bill of entry has been presented prior to the date of the entry inwards of the vessel or the arrival of the aircraft or vehicle by which the goods are imported, the bill of entry is deemed to have been presented on the date of the entry inwards or the arrival of the goods. Hence, even where the bill of entry has been presented before the date of the entry inwards or the arrival of the aircraft or vehicle, the rate of duty is determined with reference to the date of entry inwards or the arrival of the aircraft or vehicle. This is a consequence of the deeming fiction under the proviso, as a result of which the presentation of the bill of entry, when filed prior to the arrival of the goods, is deemed to be on the date of the entry inwards or the arrival of the aircraft और व्हीकल। दोस्तों इसी के साथ ही डिक्टेशन फिनिश होती है। पूरी उम्मीद है आप लोगों ने इसे अच्छे से किया होगा। स्पीड 102 की है और मुझे ऐसी हमेशा से उम्मीद रहती है कि आप लगातार इनकी प्रैक्टिस ज़्यादा से ज़्यादा कर रहे होंगे। जितने पुराने मैटर्स आपको मैं प्रोवाइड कर चुका हूँ उनकी भी बहुत अच्छे से प्रैक्टिस आप कीजिएगा। सो आपसे मुलाकात करता हूँ मैं अगली क्लास में अगली ट्रांसक्रिप्शन के साथ। तब तक के लिए बाय बाय, टेक केयर।